Entire time talking about what not to do, then what to do. On those what not to do's, if that's been done in a case, there are things that we can do to kind of salvage the situation, but we've lost some things. And I want to talk a moment about that. So, in a case where someone inherited money outright, and now they're over their limit, or they received a personal injury, and there's really nothing you can do about, as advanced planning with personal injury. That's that individual's claim, and they're going to receive money. The only thing you can do is what we're about to talk about. Okay? Let's say the person, inheritances, personal injuries. Another thing we sometimes see is they were entitled to a larger benefit on Social Security. Let's say a parent passed away, and they were entitled to go from SSI to receiving a survivor's benefit as a child who'd always been dependent upon the parents. Okay, that benefit, that survivor benefit under Social Security, is going to be a larger amount. Or there's another situation with Social Security where the individual's been working, and finally they reached a point where they could actually be receiving Social Security disability income based on their work history, as opposed to just SSI, and their benefit could be higher. Sometimes people don't catch that right away, and then they get this big lump sum. Now that lump sum for 6 months after it's received, so long as it's kept separate from other money, isn't going to be counted as a resource. But let's say you've got $20,000 and it's been sitting there for 6 months in a bank account, and it hasn't, just a little bit of it's been spent. What happens after 6 months? Now it's counted as a resource. But it was the individual's money to begin with. It wasn't somebody else's money. So what do we do with property that was that individual's money, either because they inherited directly, or an insurance policy named them directly, or it was a personal injury, or it was Social Security? What we do is what's called a self-settled special needs trust. Why do we not want to rely on this in the first instance? We don't want to rely on it to begin with because one of the key features, as I said earlier, is I'm going to have a part of the trust that says when the child dies someday, the trustee is going to have to contact Medicaid to find out what the bill is. And to the extent that there's money in the trust to pay the bill, they've got to go pay the bill. And only until the bill's been paid is there anything left to distribute within the family. Okay? And again, on the third-party special needs trust, if you did your planning, etc., you wouldn't have that requirement as part of that trust.